completely devastated, not only by the violent loss of Landon's life, but by a sudden dismissal of charges that feels entirely devoid of justice.
We were able to recover the items. However, the presence of such an item changes things.
This is a deadly weapon with an illegally long blade on the victim during a shooting. I could think of no greater exculpatory evidence.
There is a pending motion to dismiss that has been filed by the people. So let's get started there. Mr. Savicle.
Yes, Judge. As noted in our motion, we are filing to dismiss at this time to permit further investigation of the case. We are in compliance with the Victims' Rights Act. I know Reggie Mentic does not want to speak, but I believe there is one individual that would like to address the court if that's possible.
Okay. Well, Mr. Savicle, I'm not sure who's speaking, but whoever may approach, come on up to the podium.
My name is Jason Dahl.
Okay.
And Landon was my brother-in-law.
Okay.
We stand before this court completely devastated, not only by the violent loss of Landon's life, but by a sudden dismissal of charges that feels entirely devoid of justice. We were heading towards trial, and just 1 month ago, charges were upgraded. We believed the facts would finally be laid bare before a jury. Instead, 10 days before trial, we were notified that the case would be dismissed. How can a grieving family not question this process, not question the ability, integrity, and motivations behind those that are making the decisions? Landon was far from perfect, and we acknowledge he played a part in the events of that night. He may have committed a crime in his actions, but he paid the ultimate price for it with his life. He did not deserve to die. He didn't have a gun. He weighed 100 pounds less than the defendant. Most importantly, Your Honor, he was shot in the back multiple times. We struggle to comprehend how shooting a visibly unarmed, retreating man in the back can be dismissed without a jury ever looking at the facts. From the very beginning, the handling of this case has broken our trust and, in our opinion, shows extreme bias. In a small community, it took 14 hours and a voicemail from the coroner for Landon's father to be notified of his son's passing. The defendant was never given a breathalyzer or a toxicology screen at the time of his arrest, steps I think would be mandatory when a person takes another's life. Landon had ongoing interactions with the sheriff's department and had stated to family and friends that he was being harassed by them. A relative of the defendant, a sheriff's deputy, was the first on scene. How is that not a conflict? Furthermore, we have asked numerous times about Landon's personal belongings and received a "I'm not sure" response. 10 days ago, we learned that items that he had on him when he was killed have been sitting on a shelf at the coroner's office. What else has been overlooked? What evidence has gone missing? What reports have not been thoroughly read? These are persistent questions that are on repeat. With no explanation, no answers, we're left to create our own. To see this investigation handled with such critical omissions and procedural failures makes us question if Landon's death was treated with the respect, care, and dignity he deserved. Even if the sheriff's office viewed him as a nuisance, he still deserves the equal protection of the law. The sudden dismissal deprives Landon of justice and deprives our family of closure. We ask that our profound frustration, our objections to how this investigation was conducted, and our enduring grief be permanently made a part of this court's record today. Thank you, Your Honor.
Thank you, Mr. Dahl. Mr. Savicle, is there anything else that you wanted to say?
Not this time, Judge.
Then Mr. Hotchkiss.
Yes, Your Honor. We object to the motion to dismiss without prejudice and ask that it be entered as a motion, granted as a motion to dismiss with prejudice. In particular, we want to ensure that my client's right to speedy trial continues. Past today, I think we've got about 51 days. So in the event that the people refile this case, it's important that we maintain that speedy trial clock. Also, I believe Rule 48 requires for some amount of specificity. I think that people have mentioned that they want to investigate further. I do think that the rule requires them to give the court some amount of information about what that actually means.
Rule 48 does require that the motion be supported by a written statement concisely stating the reasons for the action. I understand that Mr. Hotchkiss's request is that the further investigation is not a concise statement. I would say that this court has very limited ability to deny the people's request under these circumstances, but I wholeheartedly agree with the statements of Mr. Dahl and the family regarding the sense that they must have that justice isn't being done under these circumstances. This case has been set for trial, I think, since March. It was upcharged in April. We were set today for a preliminary hearing. The trial is set to go on Monday for 2 weeks, making a decision, as Mr. Dahl indicated, 10 days before trial. Not only that you wanted to dismiss the case, but that you wanted the case to be dismissed without prejudice brings no sense of closure to anybody. And the request for further investigation is vague and does not really give anybody an understanding of what the reason is that the people cannot go forward on this case today for preliminary hearing or in next week for a 2-week trial. So Mr. Savicle, I think we all deserve a little bit more information, whether it feels comfortable to you or not, what further investigation means.
Yes, Judge. I believe the victim made mention of evidence that was sitting in the back of the coroner's office. One of these pieces of evidence was a weapon that would have been visible to the defendant at the time of the assault taking place. Because of the circumstances of the former deputy coroner, law enforcement, including myself, were completely unaware that the victim was armed at the time of the incident. That came word to us 2-3 weeks ago. And so we immediately pulled in multiple individuals. I pulled in the coroner, I pulled in the sheriff. I started asking how this happened, where it went, what it was. We were able to recover the items. However, the presence of such an item changes things. And so we are moving to dismiss without prejudice right now to determine if it could even go forward ever again. But we need to make that determination.
Mr. Savicle, if you could approach with Mr. Hotchkiss. All right, we are back on the record. The court will, because the people have made an additional record regarding their motion, and because this court doesn't particularly think that I have the ability to deny this request, there has to be just really exceptional circumstances. It is the people of the state of Colorado versus the defendant and not the court. So the decision of the people is the people's decision, and it is appropriate for the court to grant that motion without prejudice. So the court will do so today. Obviously, the preliminary hearing is vacated. The court jury trial set for next week is vacated. Mr. Chase's bond is released, and any conditions of bond are also vacated at this time with the dismissal of this matter.
Your Honor.
Yes, Mr. Ponce.
I apologize. Judge, I did want to make a record before the court's ruling. Maybe it's too late. But our concern is, from the defense standpoint, Mr. Chase has, I believe, obviously, that he was wrongfully arrested. I don't believe any of the facts from the very beginning of this matter ever supported him being charged, even in the first place. And I think that because he was charged, Mr. Chase has undergone spending a fortune, frankly, a small fortune on his defense in procuring expert witnesses, 3 expert witnesses from around the country who are the best in their fields. And I mean, he has spent $50,000 or $60,000 on these people. With the case being dismissed today without prejudice, obviously we did a lot of work to try and get these people here on July 20th or for this week of trial. We were in the middle of getting their airfare, their lodging, all that sort of thing. We paid for all these reports. And quite frankly, up until the motion was filed, we were very much prepared to proceed in defending Mr. Chase. And I'm very confident that we would have succeeded handily. I'm going to just reiterate the defense's request, understanding that the court may not grant it, that this case be dismissed with prejudice, because I did not file this motion, but I had drafted a motion for sanctions because of this issue involving this deadly weapon that was on the person of Mr. Mintink at the time of the assault. I believe what I articulated in the motion that I didn't file was that this is a very serious discovery violation. That this is a deadly weapon with an illegally long blade on the person of the victim during a shooting. That I could think of no greater exculpatory evidence, no greater evidence subject to needing to be produced, needing to be documented and put forward to the defense. And we never had that opportunity. We didn't even know about it. We didn't even know it even existed up until about 3 weeks ago. And so my request was actually going to be dismissal with prejudice as a sanction for a discovery violation. And I do think that would give the court those extraordinary circumstances that the court just stated that it would need in order to deny the motion to dismiss without prejudice and grant a motion to dismiss with prejudice. And I do think that would be appropriate here, given the fact that Mr. Chase does have a speedy trial right, and he does have a due process right, and he has spent lots of blood and treasure getting ready for this trial. And if it's the people's intent to refile, just dismiss this essentially on the eve of trial, only to investigate it and who knows, maybe refile this at some later time, that seriously disadvantages Mr. Chase, having gone through all the trouble to prepare his defense, and also not having had the benefit of preparing that defense with this exculpatory information that we only learned about 3 weeks ago.
Mr. Saville, did you want to respond? I have a thought.
Judge, I think our main response to that is simply nothing was filed. We weren't on notice to address it, but regardless, there are only very few circumstances where a case can be dismissed with prejudice, Judge, but that's simply what we'll say right now.
Well, the cases that have been dismissed with prejudice, especially recently, are the ones where there's been a significant discovery violation. This is what the court is going to do. Mr. Ponce, I wish you would have filed that motion before today, because I was ready to address this request for dismissal without prejudice and was not otherwise prepared to address other issues. I've vacated the preliminary hearing. I've vacated the trial date. I will not enter the order of dismissal today, and I will give you leave to file that motion to dismiss with prejudice. The people can you get that? It's done. Can you get it filed by the end of the week?
I can file it by the end of the day.
Okay. Mr. Savico, I can give you 14 days to respond to that motion. Do you feel like there's not a 2-week trial coming up, so there's a little bit of time on the available, at least that you're not going to be in? Can you respond in 14 days?
I can, Judge, yes.
Okay. And then a reply 7 days thereafter. And that may potentially be able to address some of the issues and concerns that are raised today. The court still will convert the Mr. Chase's bond to a personal recognizance bond in the same amount. And any bond restrictions like ankle monitor are released at this time.
Judge, we would simply just note an objection. The case, a motion to dismiss has been filed in the matter, keeping the case open to address the discovery issue. We think is inappropriate at this time. If there are discovery issues and if the people choose at some point in the future to file charges, that would appear to be the more appropriate time to do that, Judge. Thank you.
All right. I'll just note that the motion to dismiss was filed on July 7th. The amended motion to dismiss without prejudice was filed on July 13th. So even then, I think the defense would have the ability to respond to such a motion. That was 2 days ago. I think the defense absolutely has a right to be heard beyond just what's happening today. And so the court believes that this order serves the interests of all parties in this case. And so the prior order regarding Mr. Ponce's motion, which may just be a response to the motion to dismiss. I don't know how you want to frame it, but the time I'll keep the timing the same, assuming that Mr. Ponce is filing a motion, the people will respond and there can be a reply period of time. How's that work for everybody?
That works.
Do we want to set the next court date?
I'm not setting another court date. We're going to resolve this by paper.